We are back on Morning Line, our final segment this morning with District Attorney Glenn Funk here in Davidson County. And as it happens, I suspected we would, taking calls and talking mostly about the Waffle House trial, which just concluded. Thank you for coming on today.
Glad to be here.
Do appreciate it. We have Granger on line too. Granger, good morning. Do you have a question for the General?
Yes, I do. By the way, first of all, Nick, I just want to say thank you and Nick Leonardo and Channel 5 for that wonderful coverage. It was a real lesson in civics. But I guess my question for the Mr. Funk is, what about the state system? I'm a retired psychiatric social worker who worked in a different state, Oregon. Out there, we have something called the Psychiatric Security Review Board. That means if somebody is guilty except for insanity, they get sentenced to this board for supervision for the length, the maximum length they could have been sentenced for. In this case, they would have been under the jurisdiction of this board for life. It's very strict. It gives them the possibility of potential release at some point if they're stable enough. But it's very rigorous. If they walk by a bar and look in and get a smell of whiskey and have no alcohol and drugs, they could be sent back to the state hospital. There were times during this hearing, and I've worked with many people like the defendant, who I actually believed he might meet the definition for insanity. My problem is I live in South Nashville, and I don't think somebody like him belongs on the street. But let's say in good faith, I believe he met the definition of insanity. I didn't know what would happen to him, and I do not think he should be out on the streets unless he's under very rigorous supervision.
Boy, I was thinking the same kind of things that he was thinking. All right, I'll let you address that, but do you believe the jury had an understanding of what might happen to him if they found him not guilty by reason of insanity? They're not allowed to be told about sentencing. If there was a single juror on there that thought, well, if we find him not guilty by insanity, he's walking out here today, not a single jury would have voted that way. Do they have any inkling? It's just what you bring to the table with you when you're chosen.
All right, well, what's in the jury charge is that he would be held in a secure facility until while he was being psychologically evaluated.
Now, were they told, on the other hand, if they were found guilty of first-degree murder, that it's going to be life in prison? Did they know that?
Yes.
Okay,
yes.
Go on.
They knew life in prison.
Okay.
The life in prison currently means 51 years.
Gotcha.
The life without possibility of parole means life without possibility of parole. That not guilty by reason of insanity, he would be held until he went into a psychiatric facility. So, I mean, they knew that. Now, they didn't know the nuts and bolts of exactly how often he'd be reviewed and how long he'd be treated and what the minimum time before he would be released under this type of supervision. Or the maximum amount of time that until they would release him. But I mean, the problem is the judge can control it at that point, and the prosecutors don't have a say. It's all up to the doctors. If the doctors say this, then it's coming out.
John Hinckley.
So he's coming, and you know, strict supervision is strict supervision. But if you've got somebody that is hell bent on killing more people, no amount of supervision is going to keep that from happening.
All right. Good point. Let's go to Jimmy next. Jimmy, good morning, Jimmy. Do you have a question?
Yes, I was wanting to talk about our district attorney there and his service to the people of Tennessee. How he started off ripping off the people before he even got into office good. Then he puts his wife working.
Well, we're talking about the trial right now, Jimmy. I appreciate that. It's a political time, isn't it?
Yes, it is.
Okay.
Yes, it is.
Let's see. We've got Ricky next. Ricky, good morning, Ricky. What's on your mind?
Yeah.
Hi, Ricky.
I got two questions.
Okay.
One is about the guns.
Mm-hmm.
This is part of one question. Okay. They need to give the guns back, but they need to fix it where it will not fire anymore.
Mm-hmm. Okay.
And my second question, all the crime you got in Nashville and stuff like that, they need to have a car where you get in, but once you get in to steal it, you cannot get out.
You're prosecuting a lot of these carjackings and car thefts and the like. Every week, the police are reporting more cases along those lines.
Well, with regards to carjackings, right, we've actually got good news because Chief Drake re-centralized the carjacking unit. They've taken off like 3 to 4 different small groups of people who were doing 99% of the carjackings, and so our numbers on carjackings have gone through the floor. I mean, that is the last 7 months, very, very few of those. With regard to gun dispossession, maybe having the gun disabled, I think that's a great idea. Maybe ought to be looked at as we make proposals for legislation going forward. That would certainly solve this problem and would have solved the problem of Travis Reinking's father giving him guns. If those had been disabled, then Travis Reinking would have had to go out and buy himself other guns, and maybe he would have been successful at that. But this made it awfully easy for him to do these murders. And as far as cars that can be disabled, most new cars can be disabled if they're reported stolen, but as far as being able to lock somebody into the car that's been taken, I'm not sure where the technology is on that.
I've heard of some people talking about that in the past. Back to the Reinking case. With this next round of sentencing, does the judge then, and he'll be the one doing the sentencing now, not the jury, they're released from this, could it be concurrent or consecutive?
It could be.
Meaning that, again, he could say, well, we're going to line this up, so you're going to have, life 52 or whatever, and then like 300 years lined up.
Well, he could have 4 life without paroles. Boom, 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 boom.
Okay, right. So that could be one right after the other.
One right after the other. Then on the assault with intent to commit murder, he could get another 100 years on that. So every one of these victims deserves their own justice, and the judge could decide to give all of these sentences consecutive. We'll have a sentencing hearing in May about that, where folks can come in and testify about how this has impacted them and why this ought to be consecutive versus concurrent. But at the end of the day, what the jury did 2 Saturdays ago ensured the public safety that Travis Reinking was never going to get out of jail.
That's a done deal. Sometimes they say by doing it and going after these other charges, in the unlikely event somehow something's overturned, you still have these others in place. Nick and I watch real closely, and we've covered some trials before where we think, no, there's going to be some issues discussed at the appellate level. We didn't see that here. I just, have they even said, are they appealing?
Oh,
I guess you
100% they will.
100%. They didn't talk afterwards. They walked past, which I understand. But you think they'll appeal? But I just don't see.
Well, one of the reasons that the jury trial flowed smoothly, right, was that everything that we had that we thought might be objectionable, we presented to the court way in front of the trial, to where the judge could go ahead and make those rulings and hear what the defense had to say and hear what we had to say and make the rulings to where we knew what the rules were going forward, right? He had excellent lawyers. Look, if I was ever in trouble, I'd want those guys representing me, because they are professional, they're smart, they're hardworking, they knew, and they presented their case very well, right? The judge had required them to do most of their filing ahead of time, to where we had litigated all of that. One, that's the best way to run it. Anytime you've got a jury who is taking off of work to be able to fulfill their civic responsibility, we want to be good stewards of their time. In this case, it's extra important because it was going to be a sequestered jury. You don't want a sequestered jury to have to waste any of their time. We want to be able to get them home to their families and their jobs as quickly as possible. And then lastly, we're still in COVID, right? And if COVID had all of a sudden broken out in that jury, right, or broken out, or Travis Reinking got COVID, or his lawyers, or any of us had an active COVID case, right, or were infectious during the trial, that could have caused a mistrial where we had to just pack our bags up and start the trial all over again 6 months from now. So all that preparation, like I got COVID very light, fully vaccinated, it's really just the sniffles, but I tested myself because I knew I was going into this trial, and all of a sudden on that Tuesday night,
it's crazy.
It test positive.
Yeah.
So I did the quarantine. I went and I saw my doctor. I talked to him on Friday, got a note on Friday that I could participate, then actually went to his office on Monday and got a note from him saying, yeah, you're not infectious, go, and presented that to the judge. If the judge had said, I don't care, Glenn, I still want to be extra safe, then I just wouldn't have participated because the other 3 lawyers were prepared, right? If one of them had gotten it, great. Well, I could have shouldered more burden myself, right? We were ready. But the idea was, let's get this tried as quickly as possible, and let's be as prepared as possible to make sure that there was not a lot of downtime during the trial for us to have out-of-jury arguments about the propriety of any piece of evidence that we presented or any piece of evidence that they were trying to present. Because of that, we were able to get this tried starting on a Monday. We'd booked 2 weeks for this.
I thought it was 3 weeks, but it was a 2 or 3 week. I thought it was 3, we were told, and we were freaking out thinking, boy, this is going to go long. Boy, you nailed it in a week.
Right. But we, as soon as one witness was done, we were ready with the next witness. Any objections to anything that they were going to testify about, we'd already litigated. If we knew we could not go into certain areas with their testimony, then we didn't even try to go there, to where there were very few objections. Well, it was a function of the preparation as opposed to just the fact that this, maybe this was a clear presentation, because there were some issues about who could testify about what, but those were all litigated ahead of time. It's a credit to Judge Fishburne. It's a credit to the counsel, both as the prosecution and the defense, that we were able to put this on really smoothly.
Through the most of your evidence phase, there was no cross-examination because it was pretty much conceded by everyone he's mentally ill. The cross came, and where lengthy was when you had the experts on there. We didn't touch much on that, I guess. But did you get a chance after the trial at all? And sometimes they do or not. Did you ever get to get any feedback from the jurors? Just curious. I don't know if you had time.
I did not reach out to the jury. Okay. I don't know if Roger Moore, Jan Norman, or Ronald Dowdy did. I've kind of been keeping an eye on you and Nick Leonardo, who did a fantastic job, to see if any of them had reached out to y'all. One of the benefits, and I think the last caller alluded to this, is it's more than a civics lesson. If we just have these trials in secret, in court and nobody knows about them, then we cannot really have that community conversation about right and wrong, about law enforcement, about how we're handling mental health issues, right? I mean, as a city, we've been doing a lot with regards to mental health issues. We got the top mental health court in the country with Melissa Blackburn. We've got the behavioral care center that I've piloted along with Sheriff Darren Hall and Martisa Johnson, our public defender. It's amazing. We've done a lot with regards to mental health. Sometimes, though, if it gets to a point where this type of level of harm is caused, well, then that's something when the penitentiary has to get involved.
And it's good to show, though, too, as you just said, in court. And we're thankful that we have judges, and Judge Fishburne, who did a fantastic job, that are very agreeable to the media being there, which I know can be a headache. Listen, thank you for coming on. It was fascinating watching that trial, and really appreciate you coming on and answering those questions. We'll see you again soon, all right?
Sure. Be glad to.
District Attorney General Glenn Funk taking a break. I'll wrap things up right after this.